afternoon. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to provide you some updates regarding the most important, most interesting immigration news that happened during this first week of November 2020. So first of all, let me start with updating you on court-related deadlines. For the most courts, immigration courts in the United States, the hearings for non-detained respondents were once again canceled through and including November 20th, 2020. I would say that it would be safe to assume that through November, through the rest of November, these hearings are not going to take place. I'm talking about individual and master hearings for non-detained respondents. When these hearings are going to be resumed? I receive this question very often. I'm going to tell you that I believe that no one actually knows, because for that, the hearings will have to be administrated in a safe manner, which is very difficult to do with master hearings when, as you may be aware, many people have to come to a relatively small room at the same time. And because we're worried about the second wave of COVID, currently it's impossible to achieve the safety in such rooms. I think that when the hearings will be finally resumed, they most likely will be performed via phone. Of course, it will be more difficult for people who do not have attorney to represent themselves during such hearings. And of course, there is another concern, is a lack of translators, perhaps, during such hearings, phone hearings. But we will see. Maybe the court administration is going to adapt and will come up with something convenient and inexpensive to be able to implement it and carry it on. So the backlog that's currently growing and growing is not going to become super gigantic. But that you can imagine, because all the hearings have been canceled from March through current time. For New York Immigration Court, the backlog is getting pretty significant. So this is it for the immigration court updates. Now let's talk about public charge. Public charge rule that has been first canceled and then again reinstated during the same week. I know many of you are tired of this roller coaster, and many even commented on my update saying, I don't believe this anymore because it's been canceled and reinstated so many times. And you know what? I agree with you. It's kind of becoming sort of ridiculous. And it seems that the only way to resolve the issue would be if the United States Supreme Court is finally going to take a lead and will stop this madness. Okay, because we need to know as to what's going to happen, what forms to file and not file, what we have to prepare for, because currently it has been stressful for attorneys, and of course it has been tremendously stressful for clients who do not know what they need to do. Do they have to try to obtain a credit report? If they don't have a credit, do they have to get the bank statements for the past 12 or 24 months, or they just can submit the forms that are actually required by the law and not by the improvements to the system? So what to expect from this public charge? Well, I would say that it's safe to assume that until this issue is resolved by the United States Supreme Court, or perhaps by the new administration, if the administration is going to change, we will have to comply with the public charge rule. And those who are planning on filing for adjustment of status or change of status will have to prepare declaration of self-sufficiency, right? So if you are in that period of preparing your documents, right now I would have advised you to still continue your work on declaration of self-sufficiency form I-944, okay? So that's what's going on. Now, I wanted to also draw your attention to a couple of important decisions that came out this week. And one of those decisions is a matter of PAC, P-A-K, by the Board of Immigration Appeals. This case is relevant to those who are filing for marriage-based petitions, marriage-based adjustment of status, if previously they had a marriage-based petition denied. Why this case is relevant? It is because Board of Immigration Appeals stated that if there is evidence of prior marriage being fraudulent, but such a decision has never been rendered, the new marriage petition can be denied based on fraudulent prior marriage. It's called 204C bar. So traditionally we would think that the 204C bar or marriage fraud bar would be applied if there was a solid determination by immigration authorities that a person was guilty of marriage fraud, right? If there was enough evidence to charge the person with marriage fraud. Not quite so. Board of Immigration Appeals stated that that formal determination is not necessary. In the matter of PAC, for example, the case was that PAC filed, was a beneficiary, I believe, of the marriage-based petition number 2, but there was evidence that the marriage number 1 could have been fraudulent, could have been. There was no determination rendered, but could have been because the spouse number 1 was not present at the residence where she said she was supposed to be living together with the husband, non-immigrant, husband who was trying to get the green card. Then there were discrepancies in her place of work. She actually worked as a cashier in a grocery store that belonged to the beneficiary's family member, but on her paperwork she stated she was babysitter, okay? So that petition, the first petition, was denied for insufficient evidence to prove real marriage. It was not denied for marriage fraud. However, the immigration officer, when reviewing petition number 2 by the new spouse, checked the file, found that determination, and determined that the second petition cannot be approved because of the marriage fraud in a prior case. So it's a very, very important case, as I said, for those who are going through multiple filings if their first petition was denied. 204C can be used not only in connection with marriage-based subsequent petitions, but employment petitions and self-petitions. If somebody is charged with 204C inadmissibility bar of marriage fraud, it means that no petition is going to be ever approved for them, unless there are some exceptions, of course, unless it's the same petition by the same petitioner for the same beneficiary. Basically, you're marrying the same person, or the same person is filing for you. So very important case, actually, okay? Something to keep in mind. And it means, what does it mean to you? Well, it means that when you're preparing your marriage-based case, you have to come up with a very strong case and very good evidence, okay? Because if you don't, and your case is denied, even if the denial does not charge you with marriage fraud, it can be used against you subsequently, and it's very, very important to try to avoid it. All right, so that's why that case is important. And of course, there was another important case by Attorney General who stated that the assistance to the persecution of others bar to asylum and withholding of removal does not include an exception for duress. Very important, because what happens is that the Attorney General is trying to reshape the way someone can qualify for asylum. Okay, the burden, basically, if you read the case, and I'm going to publish the name of the case because I cannot pronounce it, unfortunately, in the comments to this video. If you read the case is very long, and it talks about different burdens, but it all comes down to one simple fact. You, as an applicant for asylum, prior to filing your claim, will need to identify potential issues and potential problems, potential bars to asylum that the government may impose against you, and disprove them at the time of the filing. It sounds crazy, but that's what it comes down to. Okay, because basically they're saying that it's not the government's burden to come up with this bar, it's your burden to establish your eligibility for asylum. And once the government says that there is a bar to your asylum, it's up to you to prove that the bar does not apply. It's important, all right? So basically what happens is that you have to disprove your case prior to being charged with anything. It's disprove your guilt, so-called. That's how at least I saw the result of that decision. And it's very important because it happens, this rationale is going to be used by the government for other areas. For example, potential bar to asylum because of the relocation, okay, that you can relocate and live safely somewhere else. This assistance to persecution of others, by the way, this bar very often is used in gang-related cases. It sounds crazy, but I remember I read the case when a lady was extorted by the gangs and provided money to them, and she was found to be an assistant to gangs because she supplied funds to them, which sounds crazy because she did not do it voluntarily, and it was like a $4 or something amount that you know, she was very poor and didn't have the money, but they took last pennies that she had, and nevertheless her asylum claim was denied and she had to go through appeals. I believe she was successful on appeal, but this is something to know. You need to know about that, especially if your claim involves some sort of extortion, okay, extortion by the gangs, for example. This is something, one of those legal things that your lawyer will have to prepare you for, all right? Because it sounds like crazy that you can be denied asylum because you were a victim of extortion, but that's unfortunately happened to people before. So these are the updates for this first week of November, and I hope you will find them helpful. Please subscribe to my channel, like and share this video, and I wish you to have a very good weekend, and I hope to see you soon.